हॅलो गाईस, वेलकम टू इझी लीगल लॉ. आपण पाहत आहोत रिअल इस्टेट लॉज. In Maharashtra Rent Control Act 1999, Chapter 5 provides a special provision that bypass the standard, often lengthy court procedures. That provisions are designed to protect specific classes of people like soldiers and scientists and to encourage homeowners to rent out property through the live and license system without the fear of permanent tenant occupancy. Section 24, the live and license system. This is the most powerful way to rent property in urban Maharashtra today. Section 24 provides a fast track remedy for landlords to recover possession of residential premises. Mandatory vacating on expiry of license period. The licensee must deliver possession back to the landlord. Double damages. If licensee fails to vacate, they are liable to pay double the license fee for every day they overstay until they are evicted by the competent authority. The conclusive evidence rule: if there is a written agreement, it is considered final proof of the facts stated within it. The licensee cannot argue in court that they are actually a tenant if the paper says they are a licensee. Jurisdiction: these cases are filed before a competent authority, not a regular civil court, which follows a summary procedure to decide the case quickly. Section 23, members of armed forces and scientists. The act recognizes that those serving the nation often face housing difficulties upon retirement. Section 23 gives them a superior right to recover their own homes. Who is covered? Member of armed forces, scientist working in high level government research, successor in interest like widow or family members if the officer scientist dies. The right: they are entitled to recover possession of any premises they own if they need it for their own occupation. Simplified proof: a certificate signed by their head of department or a high ranking officer is considered conclusive evidence of their status and their need for the house. The court generally cannot question the necessity if the certificate is valid. Government servant, Section 23, Subclause 1A3. Similar to armed forces, regular government employees, state, central, or PSU have a special window to recover their homes. Timeline: they can apply for possession within 1 year before or after their retirement. Constraint: they must prove they do not own any other suitable residence in the same local area. The Maharashtra Rent Control Act 1999 provides a specific legal highway for owners who use the live and license system. These provisions are designed to be fast track, ensuring that a license does not gain the permanent protected tenant status that has historically made landlords wary of renting out their properties. Section 24, special provisions for licensor. Section 24 is the most critical tool for modern landlords in urban Maharashtra. It creates a summary procedure for recovering possession of residential premises. Mandatory eviction: once a leave and license agreement expires, the licensee is legally obligated to deliver possession to the licensor. The competent authority: disputes under these sections are not heard in regular civil court. They are heard by a competent authority, usually a retired judge or high ranking officer. This authority follows a simplified process to reach a decision quickly. Leave to defend: unlike regular lawsuit, the licensee does not have an automatic right to fight the case. They must apply for leave to defend. If they cannot show a strong prima facie reason why they should stay, the authority will reject the application and pass an eviction order immediately. Double damages: if the licensee continues to stay after the license has expired or been terminated, the competent authority can order them to pay double the license fee as damages for the period of illegal occupation. Conclusive evidence: any written agreement is considered conclusive evidence if the fact stated therein. This prevents the licensee from claiming they are actually a tenant with permanent rights. Section 55, effect of non-registration of agreement. While Section 24 offers great protection to the landlord, it is strictly conditional upon the registration of the agreement. The duty to register: under Section 55(1), every agreement for letting or leave and license must be in writing and must be registered under the Registration Act 1908. Landlord's responsibility: The responsibility of the agreement registered lies entirely on the landlord. Presumption in favor of the tenant. This is the sting of the law for negligent landlords. If the agreement is not registered, Section 55(2) states that the contention of the tenant licensee regarding the terms and condition of the lease shall be presumed to be true unless the landlord can prove otherwise with overwhelming evidence. Criminal penalty. A landlord who fails to register the agreement can be punished with imprisonment for a term which may extend to 3 months, a fine which may extend to 5,000, or both. Loss of summary benefits. If an agreement is unregistered, the landlord may find it significantly harder to use the fast track recovery benefits of Section 24, as the competent authority may refer the matter to a regular civil court to determine the actual terms of the unwritten or unregistered deal. Section 44, no appeal, only revision. To ensure speed, the Act specifies that no appeal shall lie against an order for the recovery of possession made by the competent authority. The only recourse, an aggrieved party, usually the licensee, can only file a revision application to the state government or the High Court. This is much narrower in scope than an appeal and is usually only granted if there was a major legal error by the authority. Section 23 of the Maharashtra Rent Control Act 1999 provides a specialized fast track mechanism for members of the armed forces to recover possession of their premises. The law recognizes that those serving the nation should not be entangled in decades long litigation to live in their own homes upon retirement or during services. Section 23, subclause 1. Who can apply? This special right is available to active members, those currently serving in the armed forces of the Union, retired members, those who have retired, including premature retirement, successor in interest. If the member dies while in service or within 5 years of retirement, their widow or dependent family member can exercise this right. The core entitlement, notwithstanding any other provisions in the Act or any contract, these landlords are entitled to recover possession of their premises if they require them for their own occupation or for the occupation of any member of their family. The conclusive evidence certificate, the most powerful tool in this section, is the evidentiary requirement. To win the case, the member must produce a certificate signed by an authorized officer of the rank of gazetted officer in the armed forces or the relevant ministry, stating that the applicant is or was a member of armed forces. The applicant does not possess any other suitable residence in the local area where the premises are situated. Legal effect: once this certificate is produced, the court or authority must accept it as conclusive proof of the facts stated therein. The tenant cannot argue that landlord's need is not genuine or bona fide, which is the standard defense in the regular eviction cases. Section 24, penalties for misuse. To prevent landlords from using service status just to kick out tenants and hike rent. Occupation rule: the landlord must occupy the premises within 1 month of getting possession. Reletting bar: the landlord cannot relet the premises to anyone else for a period of 2 years. Penalty: if the landlord fails to occupy or relet the premises within this window, the court can order them to put the original tenant back in possession and the landlord may face fine. Chapter 8 of the Maharashtra Rent Control Act, Section 39 to 52, establish a fast-track quasi-judicial system. This system is designed to bypass the traditional delays of civil code for specific categories of landlords, licensor, armed forces, and scientists. Section 39 to 40, the competent authority. The competent authority is a specialized just for these fast-track cases. Appointment: appointed by the state government via notification. Eligibility: must have been done a deputy collector or higher, a civil judge junior division, or an advocate with at least 5 years of practice. Legal status: deemed to be a public servant and a civil code for certain legal purposes like handling contempt or judicial proceedings. Powers and functions: the authority has power to issue summons, follows a specific format, Schedule 3, sent via registered post. Grant or refuse leave to defend. This is most crucial critical function. The authority decides if the tenant has valid enough reason to even fight the case. Order eviction. If the tenant doesn't apply for leave or if their leave is rejected, the authority passes an eviction order. Award damages can order a licensee to pay double the license fee for overstaying. Section 43, summary disposal and special procedure. This is the engine of the fast track system. It differs from regular trials in three ways. Strict deadlines. A tenant's license must apply for leave to defend within 30 days of receiving the summons. Affidavit requirement. The application must be supported by an affidavit disclosing facts that would disprove the landlord's claim. No automatic trial. If the tenants fail to apply within 13 days, the landlord's statement is deemed admitted and an eviction order is passed immediately. Section 44 and 47, bar of jurisdiction and no appeal. To maintain speed, the Act removes the usual layer of civil litigation. No appeal. Section 44. 1 explicitly states that no appeal lies against any order for recovery of possession made by the competent authority. Revision only. An aggrieved party can only file a revision application to the state government or an officer not below additional commissioner within 90 days. Bar of Civil Courts, Section 47 prevents regular civil court from entertaining any matter that the competent authority is empowered to decide. No injunction can be granted against the authority proceedings. Section 45, enforcement of orders. The authority doesn't just pass order, it has muscle to execute them. The 30-day window, once an eviction order becomes final, the occupant has 30 days to vacate voluntarily. Forcible eviction, if they refuse, the competent authority has power to physically evict the person and hand over possession to landlord using police assistance if necessary. That was all for this video. See you next video. Till then, please like, share and subscribe. Thank you.